Hello YouTubers, this is Kelly Blatnik with Blatnik Law LLC. Please feel free to check out my website, www.blatniklaw.com. Today I'm going to briefly discuss a couple of cases are coming up before the Nevada State Supreme Court on June 1st, 2020, one at 1:30 and the other one at 2:30 for oral arguments. I personally found the 2:30 p.m. case more interesting, so that's what I'm going to discuss first. In the state of Nevada, there are two conflicting statutes regarding a mental disease or illness affecting or impacting the culpability or what's going to happen with a criminal defendant. In the 2:30 case, it's Kassa versus State. The jury returned a verdict that was guilty but mentally ill, and that would be under Nevada Revised Statute 176.057. What the Public Defender's Office is arguing is that it should have been an acquittal, and the acquittal would have been NRS 175.381. It doesn't seem that either the state or the defense disagrees regarding the mental illness of the defendant. The issue comes down to, was it proper for the court not to grant an acquittal? Was it proper for the court to allow the verdict to stand of mentally guilty but mentally ill? Very interesting as to, I personally find that case to be very interesting as to what's going to come out as to whether or not the defendant is entitled to an acquittal based upon mental disease or defect when the jury already determined guilty but mentally ill. The 1:30 case I didn't find as interesting, probably because I just personally didn't find it interesting. And there were 11 reasons for appeal, and when you get to that many reasons, I think we get lost in the bushes or lost in the forest somewhere. The reasons for the appeal were denial of a fair cross-section, challenges to the venire, meaning that the people that the defendant got to choose from for the jury pool just didn't represent a cross-section of the populace, and therefore he was denied his right to a fair trial. The second reason was limiting his reserved opening statement. Third, allowing an in-court identification. Fourth, refusing to give a lost evidence instruction. 5, refusing to give a petite larceny instruction. It seems to me the defendant was trying to get a lesser included instruction that wasn't given. I don't know why number 6 was missing, but it skips over to 7. Mishandling a jury note that suggested confusion about an element of the offense charged. 8, not allowing the trial judge to hear his post-verdict motions. 9, denying his motion for a new trial based upon newly discovered evidence. It's always really hard to get those. 10, denying his motion to reconstruct the record. And 11, committing cumulative errors. So 11 is, because of all these other reasons, this person should get a new trial. So those are the two oral arguments that are coming up. Once again, it'll be June 1st, 2020, starting at 1:30, and then the second case will be at 2:30. And if you want to go online and see those oral arguments live, go to inthecourts.gov/Supreme. Court is plural with an S.